Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who've been geeking out on this channel or other channels similar to this, you know that last week, April 11th, the Department of Justice, Merrick Garland, and your ATF published a new set of rules, new regulations in the Code of Federal Regulations that would significantly redefine frames, receivers, firearms, and various other components. We've done videos on it ourselves here, talking about how obviously the role or the goal here of the federal government was to expand the scope of definitions, bringing more people, activities, and components within the confines of federal control. Well, they have done exactly that. But many of you are still freaking out as to how bad is this. And I want to take a very short video today and talk to you about one of the most important questions that all of you have right now, which is, do I really have to get all of my lowers engraved? Okay, before we get rolling, you guys know the drill. If you like this video, click the like button. If you want to stay up to date on issues related to this kind of stuff, go ahead and click that subscribe button. Click the little bell logo if you want to be notified when we post new videos. And most importantly, let's keep the comments and discussions coming. That's how we're going to make sure we're getting our video out to more lawful and responsible gun owners like yourself. Okay, so when the federal government decides to publish new CFRs, they will propose a huge rule-making order that will go through all of the reasons why the new laws are necessary and all of the public comments, of which there were 290,000 comments, so good on all of you, the lawful and responsible gun owners out there. And in response to some of these comments, now in response to some of these comments, the ATF actually gave us some nuggets. I'm doing a much larger video about all of the nuggets that you can find there, but this is a short one because the issue is this. Everyone is thinking, okay, with this new regulation, I have several personally made firearms, and that's the term I'm using because that's the term that the Department of Justice is now using. PMFs, personally made firearms, much more euphemistic than ghost guns. Homemade firearms is what we can call them as well. Okay, for personally made firearms. Now, if I want to keep all of them, I have to have them serialized, right? I have to go find an FFL who has to be a manufacturer who can actually do the serialization and is willing to do that. Absent that, I'm going to become a felon. I can't possess these firearms anymore, right? Au contraire, that is actually not the case, and I want to show you where you can find the answer to that. Okay, now I'm going to put a link for this full report down below, and in this report you will see sections in which the Attorney General has to respond to comments, and so many of the comments will be kind of summarized, and then the Attorney General needs to respond to that. In some instances, it actually resulted in the Attorney General and the ATF actually changing the definitions that they were going to use. But one of the things was there was a lot of people concerned about the number of firearms that were going to have to be engraved, and that there are simply way too many, and there wouldn't be enough FFLs available to do the engraving. And it was a combination of look at all the personally made firearms that we have out there and look at what few FFLs can actually do that. The ATF clarified, really in attempting to clarify how many different FFLs can do it, told us something very important, and this is what I want you to pay attention to. Please remember this, because the ATF says the following about what needs to be serialized. ATF reiterates that personally made firearms for personal use are not required by the Gun Control Act or this rule to be serialized unless required by state or local law. Instead, serialization is required only for those that are taken into inventory, which, as the final rule clarifies based on ATF's longstanding view, does not include same-day adjustments or repairs. So this is important. An untraceable firearm, that is a firearm that does not have a serial number, a personally made firearm, does not need to be serialized unless it goes into inventory at an FFL. Any FFL who takes an unregistered or an unserialized firearm into their possession and keeps it for longer than 24 hours shall serialize it. That means if we have personally made firearms that need to go to the gunsmith for repairs, as long as the repairs are done the same day and we return the firearm, we're good to go. If it stays overnight, though, by law, they would then have to serialize it. So, do we have to go out there and serialize all of our untraceable firearms? Do we have to go out there and serialize all of our homemade firearms or our personally made firearms? The answer is no, we don't. Again, Down below, I'm going to put the link for it. It's page 259. It's right there, plain as day, page 259 of this report. But the ATF has made it very clear, the Department of Justice has made it very clear that the serialization requirements for personal-made firearms which go into or come into inventory for licensed FFLs. That's what the rule applies to. Listen, you may have more questions about this rule, any of this other ridiculous stuff going on, or anything else related to your Second Amendment rights. And if you do, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.